Well, in all three leader debates, and especially with these so-called teal independents, much is being made of integrity. Labor, of course, want a federal integrity commission, and the Prime Minister has set his face against it. The Prime Minister is right. Reputations have been destroyed in New South Wales via ICAC. But if integrity is an issue at this election, surely the first trashing of integrity lies with these so-called independents, who won't indicate to whom they would give support if there was a hung parliament. Now, this election is about deciding who should govern Australia, and they won't tell us who they will support to form government. Integrity, nil. Professor David Flint is an Australian legal academic of remarkable distinction, and he joins me on this issue of integrity and other matters. Professor Flint, thanks for your time. You've studied the operations of New South Wales ICAC. Should that be a model for a National Integrity Commission?
Certainly not. It breaches the fundamental rule that nobody should be found guilty unless this is proven beyond reasonable doubt before a judge and a jury. And here you have questions being asked in public without the rules of evidence applying, and people being treated as if they were guilty of an offence when they're not. And the resources of the Commission being used, for example, against completely innocent people in relation to something hardly related to corruption. And I look at it in particular, the case of Margaret Kineen, a silk who was the subject of an assault by ICAC, really a persecution by ICAC, which she had to take to the High Court to protect herself.
Yes, indeed. And then, of course, the New South Wales government passed retrospective legislation to validate all decisions prior to that case, to validate them, independently of the merit of them, validate them. What the public don't know here, David Flint, is that no conclusion by ICAC and no evidence presented at ICAC is admissible in a court of law.
Exactly, and this means that even if they're onto something important, as they often are, and this is no criticism of them in this regard, but this means that then the matter then has to go to the DPP. The DPP has to conduct a separate investigation to accumulate all of the evidence. So you get this very lengthy delay, unnecessary delay, which is obviated, for example, in the United States, where they have a special counsel and it goes before a grand jury, and the grand jury decides whether the whole case should go before a judge and a jury. You need something much more expedited. It's a very poor model, and I'm surprised that anybody would suggest the ICAC model as the appropriate model. And this is no criticism of them.
No, I mean, there are authenticated reports, which I think the public don't understand, that 128 people have been defamed or destroyed by New South Wales ICAC, yet the Prime Minister, for his trouble, has been indirectly called a buffoon by one of the three ICAC commissioners, Rushton SC.
Well, I find that a very, very persuasive form of argument to call somebody a buffoon. But the point is, you redesign the model, and there are plenty of models.